If you already have a will, do you still need a trust? Now, a lot of people assume a will is all they need. And for some families, that might be true. But in Florida, the difference between a will and a trust is much bigger than most people realize. And understanding how they work and what each one actually does helps you to make the right choice for your family. So let's walk through this in a clear and practical way. The first thing you need to understand is this: a will does not avoid probate, but a trust does. And that one distinction is a game changer for a lot of families. When someone passes away with only a will, the will has to go through the Florida probate court. It must be shown to a judge, validated, and formally processed. Now, that means your family will wait a long time. They deal with legal fees. They need court approval for many steps, and everything becomes part of the public record. A will is basically a set of instructions for the court. A lot of people think it's a tool to bypass the court, but it literally guarantees that your family will end up in court. People are often surprised by this, but probate is required even if the will is perfectly written. It is simply part of the process. So let's talk about a trust instead. A trust works completely differently. A trust avoids probate entirely. When assets are titled in the name of your trust, your successor trustee can step in immediately with no court involvement at all. So what that means is no delays, no filings, no hearings, no paperwork back and forth with the judge's office. The assets transfer privately and efficiently. And that's why so many of my clients, so many families choose a trust. It keeps everything smooth, private, and under your control, even after you're gone. Now, I want to explain the biggest misconception. Some people believe, well, probate won't be that bad, right? I don't have a huge estate, so it's not going to be that bad. But probate isn't just about the size of your assets. It's about the process. Even a very simple probate in Florida takes months. More complicated ones can take a year or years. And the fees, well, they add up quickly. You have attorney fees, personal representative fees, court fees, publication fees. And if you have real estate in multiple counties or other states, the complexity multiplies. A trust avoids that entirely, but a will cannot. So let me give you a real life example. I'm not going to mention names, but just to present the idea. A woman in Broward County passed away with a beautifully written will. Everything was clear. She left her home to her son, and for her daughter, she wanted her daughter just to get her savings. So house to the son, money to the daughter, right? Sounds simple. But because she had only a will, her family still had to go through probate, and it took nearly a year before her beneficiaries, her children, received anything. The son could not sell the home until probate was completed, and the title had to be cleared through that process as well, which delayed the process even more. Meanwhile, the son was stuck having to pay property taxes and continue with HOA dues and other upkeep for the property. And none of this would have happened with a trust. With a trust, the son could have transferred or sold the property immediately without needing court approval. The difference wasn't in her plan, right? It wasn't about who she wanted to get what. The difference was in the structure. Now, let's take another quick example. A gentleman in Miami, he left everything to his nieces and nephews because he didn't have any children of his own. Now, he had a will that spelled out each gift very clearly. But because he lived in Florida and owned a condo, bank accounts, and a vehicle, everything had to pass through probate. And because there were so many heirs, everyone had to be notified, consent had to be managed, and the process took nearly 18 months. Again, during that time, HOA fees piled up, the condo needed maintenance, and things became stressful for the family. A revocable living trust would have eliminated every one of those problems. The trustee could have stepped in immediately, sold the condo, settled the accounts, and distributed the funds privately. So, does that mean that everyone absolutely needs a trust? Not necessarily. If you really do have a very simple estate, maybe one bank account, no property, like no real estate, no minor children, and no blended family dynamics, And if you don't mind the beneficiaries that you're going to leave behind going through probate, then a will might actually be enough. But most families in Florida benefit from a trust because of the privacy, the speed, and the ability to avoid the court system. And if you own real estate, especially your residential home or even investment properties, a trust is almost always the better option. Let's talk about for a moment though, what about if you have minor children? If you pass away with only a will and you leave money to your minor children, Florida requires a guardianship. That means the court controls how the money is handled. A judge decides who manages it, how it's spent, and how it must be reported. And at age 18, whatever is left is handed directly to the child. Now, I don't know about you, but I have a 17-year-old son. He will be 18 soon. And I can't imagine if I passed away and he's a minor and all I had was a will, he would just get a lump sum of whatever I left, whether that's cash in the bank or life insurance or property. At 18 years old, it passes to your child because they're no longer a child. Now they're an adult. But with a trust, you can choose a trustee. That's someone that you trust who is going to oversee those funds. And you can set guidelines for how the funds should be used. And you can delay the distribution. So you can say, I want to delay this until my child reaches whatever age you think is appropriate, maybe 25 or 30, or in stages over time. A will cannot do that. A trust gives you far more control. Another reason people choose trust is to avoid family conflict and drama. Probate creates an opportunity for disagreements. A trust reduces that risk because everything is handled privately without court supervision. When everything is already organized in a trust, the process is so much smoother, clearer, and much less stressful. And your successor trustee can step in immediately, which gives your family stability during a difficult time. Now, one more important point. A trust does not replace a will. You still need both. The will acts as a backup. We call it a pour-over will. If you have a trust, we'll also create a pour-over will, which catches anything that was not transferred into the trust during your lifetime, and it directs it into the trust after your passing. That way, even if you forgot to move an asset into the trust, your plan still works. So, do you need a trust if you're already set up with a will? In Florida, for many families, I would say the answer is a yes. A will is a great start, but it doesn't avoid probate. It doesn't provide privacy, and it doesn't give you the same level of control for minor children or complex family dynamics. A trust protects your loved ones from the delays and the costs and the stresses of the probate process. It gives you control, and it gives your family peace of mind. So I hope that helped. If you have a question that you want answered on a future episode, please send it my way. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.